Okay, so in other words, you have to say, I want my lawyer to stop asking me questions. Is that what they're getting at?
You still haven't invoked anything.
All right. Has he been Mirandized yet or anything?
I Mirandized him.
Did he invoke?
He said he wanted a lawyer, and then he kept talking. So this right here,
where they want you to actually say verbally, I invoke my right to remain silent. You can't just remain silent and it have standing, right?
Yeah, that's actually right, because in the case of Salinas versus Texas, Salinas remained silent when they were during questioning, and they used the silence against Salinas. And then, so this gets into all these little different traps, though, because then in Hoffman, there's the Supreme Court where in Hoffman, they ruled that if you invoke your Fifth Amendment, that's actually incriminating in itself. Therefore, you shouldn't be required to invoke it. It should naturally occur through silence.
All rights should be self-executing rights, so to speak. So tell me about Hoffman. Hoffman what? Tell me about Hoffman.
Well, yeah, it's interesting about Hoffman is it says that all, not only speech, but papers and effects and actions are considered, if they're self-incriminating, then they're protected under the incrimination clause.
Okay.
And that they also mention that if you have to tell the officer, okay, so an example I'll give you is in Mimms, Pennsylvania versus Mimms. Mimms was arrested for the gun on his side. But the only reason that gun on his side was exposed is because the officer told him to get out of the car. He self-incriminated. So had he invoked the Fifth before he got out of the car and said, I invoke my Fifth Amendment right against self-incrimination by getting out of this vehicle, I could incriminate myself, he wouldn't have had to have gotten out. That's Hiibel logic. But Hoffman said by him saying that, he's now incriminated himself because he just told the cop that by getting out can incriminate him.
So it's a catch-22. So they would have never known that Mimms had a gun on him if they didn't force him out of the car under Mimms, right?
Exactly.
And if he has the right to not incriminate himself, in other words, stay seated where he's at, they would have never known he had a gun on him. So just the fact that they forced him to get out of the car, they forced him to self-incriminate himself because then his firearm became visible, right?
That is right.
So that's Mimms. They can force you out. And also in Mimms, I believe you told me, Pennsylvania versus Mimms, everybody, is the cop's favorite case law to force you out of the car. And the courts have ruled that it's a minor inconvenience to your Fourth Amendment right to privacy, or it's a minor inconvenience to your rights to force you out of the car. So any inconvenience to any right means they're violating that right. So that's total BS on its face. Also, Pennsylvania versus Mimms, which I believe you explained to me, they could tell you to get out of the car, but then after that, they have no right to tell you to get back in your car. Am I saying that right?
Well, that's exactly right. So that's what the cops didn't realize, and we're bringing to light here today. So I've seen it on cop training videos and stuff, where they tell you Pennsylvania, and I've seen it in their body cams and all stuff, where they're quoting Pennsylvania versus Mimms, we have the right to get you out of the car and all that stuff. They know that one very well. Okay, well, the justices specifically said it's only deciding whether or not the police can have a driver stand next to the vehicle or remain inside the vehicle at the traffic stop, because they said it's universally safer. And they used these post hoc studies that were ridiculous, but their justification was that it's universally safer when the driver is out of the vehicle.
Can I stop you there again? Sorry. Sorry, please. So they've decided, the Supreme Court justices, that it's universally safer for a driver to be outside the car versus inside the car, which is complete. If anyone has any critical thinking ability, a cop is far more safe with you seated in the car facing one direction versus having you out of the car, able to move around freely, able to get to them faster. Anyone with a brain would realize it's universally safer for the police officer to have you in the car. That way they could come off to the side. You have to reach this. Whereas if you're head on right in front of them, now you can reach them. Now you can get to them. Now you can run at them. You can run away from them. So anyone with half a brain would know that it would be universally safer for your subject, your traffic victim, to be inside the car, but somehow the justices said that it's universally safer for a police officer if you're outside your car, which is nonsense. Sorry to keep butting in, but thank you. Go ahead.
No, thanks. And, I will give credit to the dissenting judges who pointed out the very things you're saying. The dissenting judges were very critical of the decision and pointed these things out very clearly as well. And what's interesting about it, though, is it was great for us because what they did was they locked in the one-way command trap for these police, because now it's universally safer, according to the Supreme Court, for drivers to be out of the vehicle, which means, according to the judicial system, the Supreme Court, if you get at a traffic stop and jump out of the vehicle, a cop cannot, I mean, again, I'm not a barred attorney and this isn't legal advice, right? But for entertainment and from what we're saying, from what I've read, a cop cannot order you back into a vehicle. That's actually anti-Mimms logic. That's anti-officer safety.
So in,
and
other
he
words,
can't order.
so in other words, they said it's universally safer for the person to be outside the car. So once they order you outside the car, if they order you to get back inside the car, they're going against the judge's own ruling where you're universally safer outside the car. So for them to order you back inside the car, they're going against the ruling itself, right?
Yeah, and particularly the ruling, the judges specifically said the only question that we're answering here in Mimms is whether or not the officer can order the driver to stand next to the vehicle during the traffic stop. They can't order you to sit down. They can't order you to stand on the sidewalk or stand over here or stand over there. Nothing. The only question they answered was, can the officer order you out to stand next to your vehicle during the traffic stop? Other than that, they can't order you back in. They can't order you do anything else according to Mimms. And that's interesting to know also is that Pennsylvania, the Supreme Court of the state of Pennsylvania, okay, where I want to go with this is this thing called legislative authority. So they technically can't even order you next to your vehicle without legislative authority. Police have to have legislative authority granted by legislators. That's how they get their power. The justice, the Supreme Court can't grant police powers. They can only say what's constitutional if there's legislation in place. So they can say, yeah, it's not a violation of the Fourth Amendment, but that doesn't mean the cops can go do it. That means, okay, now state legislators can create a law that says police have this legislative authority and also outline that citizens have these obligations, these statutory obligations, because you have to be told what you're obligated to do. So, for example, you'll see in your like highway statutes that if you're stopped by a police person with the lights in a marked vehicle, you have to present your ID at a traffic stop. Now, there's a reason that's written in the statute, because that's called a citizen obligation. It's written in the statute. It's created by legislators. That tells you what you have to do. There's not a statute that says if a cop tells you to get out of the car and stand next to it, then you have to do that. No, that's not a citizen obligation. It's just they can make that into legislation, but they haven't, first of all. And Mimms challenged that under the 14th Amendment, and the Pennsylvania Supreme Court said it was a 14th Amendment violation and a Fourth Amendment violation. And then when it got up to the United States Supreme Court, they didn't address the 14th Amendment violation that he challenged it under originally. So,
and what would be the 14th Amendment violation?
So the 14th Amendment would be the due process of the state. The Fifth Amendment is often referred to as due process clause, but that's often just to the feds. The 14th Amendment incorporates due process to the states as one of the clauses. So it was a due process violation because there was no legislative authority. And in fact, because there was no Mimms, there was no Mimms before Mimms, first of all. So how is he to know that he had to get out of the car? They used post hoc, they said, well, after looking at it, we're going to do a balancing act. And now we think it's universally safer. But it's not fair to tell the citizen on the street in these high pressure situations, you have to do a balancing act, which what you think is better for the state versus what's better for your rights, and just go by that rather than going by what the letter of the legislators have written. No,
okay.
You know what I'm saying?
Sure.
Yeah, and Mimms said, and there's tons of case law that back this up, like Kolender and all these cases that say if you have a vague or ambiguous statute, that it's void on its face,
Void for vagueness.
Exactly.
All right.
And okay, and so that's actually where the next step is that all of these statutes are becoming void for vagueness because of these very reasons that we're talking about. So, for example, the lawyer dog case, the guy he said, maybe I should just get a lawyer dog during his interrogation.
Oh, this is funny. Go ahead. So start over with that. The lawyer dog case. Tell us about that one. What is that case? What's it called?
That's Demesme versus Louisiana.
Demesme versus Louisiana. What happened in that case?
So the guy's under interrogation,
Where?
and he's like under. Well, the point is it's like a formal interrogation. The point
Okay.
is that Miranda's about to apply, right? So had he properly invoked his Sixth Amendment right to counsel, everything would have been fine. But he said, well, maybe I should just get a lawyer, dog. Now,
So maybe I should just get a lawyer, comma, dog. But they
Yeah.
interpreted it as maybe I should just get a lawyer, dog. In other words, a dog that is a lawyer, right?
So okay, so I will say this is the thing. That's how the story is told.
Uh-huh.
That that because he said dog, and there's no such thing as a lawyer dog, that it didn't count. However, the way the way I see it though too is he also said, well, maybe I should.
Okay.
So
So he didn't really say I want my lawyer. Okay, go on.
He can say, and they'll tell you, that's great, you want your lawyer, but until you invoke your right to counsel, you can want your lawyer all day long. Now we're going to keep questioning you.
Okay, so in
That's
other
not
words, you have
that's
to
not
say, I want my lawyer, stop asking me questions. Is that what they're getting at?
You still haven't invoked anything.
How do you invoke it? I invoke my Sixth
Sixth
Amendment,
Amendment right to counsel. Yeah, it's the right to counsel, exactly.
Okay.
And the reason that that's important is because Hiibel specifically says this. Hiibel specifically says you can't invoke your Fifth anymore. You have to invoke specific clauses. And Hiibel, they said, had he invoked his Fifth Amendment right against self-incrimination, then he wouldn't have had to ID. But he can't just blanketly invoke a right because they include several clauses. So they're going to say, well, we didn't know which clauses you were invoking. You know what I'm saying? So here's the thing, though. They call it being vague and ambiguous. They say that's a vague and ambiguous invocation. It's not. It has to be unequivocal, is what they call it. It has to be an unequivocal invocation of rights.
So within the Sixth Amendment, there's several different things in there, and if you don't specifically say, I invoke my Sixth Amendment right to counsel specifically this part of the Sixth Amendment, they're going to consider it ambiguous, so they don't know exactly which part of the Sixth Amendment you're invoking, and for some reason, that's not a self-executing right. Is that where I'm getting so far?
I mean, that's what it's come to, yeah.
Okay, go on.
Yeah, and I don't know. So, so the idea is they say that us as citizens can no longer be vague and ambiguous. We have to be unambiguous and unequivocal in our invocation. So, and that's fine, but now we got to hold them to the same standard. So they can't have these vague and ambiguous laws and expect us to be unequivocal with our invocations, right? So, for example, there are laws on the books right now that are unenforceable. Like an example of one is like the nudity law in New York was like shot down, and there's several of them riddled throughout the different states, but they're still on the books. And so no one can know which statutes are valid, but just by reading the statutes. You can't just go into your state statutes and read them all and say, okay, this is the letter of the law. No, if you do that, you're going to be losing some rights because there are actually invalid statutes in there that you're going to be abiding by, therefore chilling your actual freedom,
So there's laws on the books that have been overturned, but they just leave them there?
Yeah, and they're unenforceable. So and it's like hard to get them off the books. These laws aren't being audited and cleaned,
Or revised.
Yeah.
Okay.
And then also, so what goes into this unclean statute system is in 2020, the Ramos case discovered, this is where the unanimous jury comes from. I don't know if it hasn't really caught much news, but it's really interesting that now they're requiring a unanimous jury for convictions or acquittals. Just a trial jury has to be unanimous. That was through Ramos' 2020 case, where he said that the Sixth Amendment not only implied the right to a trial jury, but it has to be a unanimous jury. Before they were doing it like 7-9, guilty type stuff, or 7-2 or whatever, 7 out of 9 type stuff.
Majority.
Yeah, but what he realized is that there was what was called an implicit right. It wasn't an explicit right within the Constitution. So within the Sixth Amendment was an implicit right, the right to a unanimous grand jury. It
Okay.
wasn't explicitly stated. So people had been getting their right. Yeah, people had been getting their right to a unanimous grand jury violated for the last 200 years until Ramos in 2020 figured it out. And now you have to be a unanimous jury.
So Ramos in 2020 solidified that if you get a jury trial, you can only be convicted or acquitted, and the jury has to be unanimous. They can't go by majority of the jurors anymore.
Right.
Okay.
And what's interesting, I call that, this is why the protocol calls Ramos gem, which is he just discovered something in the Bill of Rights that none of us had seen all along. He discovered another right, another clause within the clauses, and it's an implicit right that he made explicit. Now Miranda did the same thing. Miranda found an implicit right and made it explicit. You have to be Mirandized. You have to be notified of your invocation rights in real time. And that's what the violation of Mimms was. Mimms wasn't notified of his invocating rights in real time. When people are stopped and ID'd and they're not told that they can invoke their fifth, that goes against the Miranda gem, that you are required to be notified in real time of your invoking rights when you can invoke them.
Give us an example of that. So they stop you on the street and they go, "Hey man, you got ID?" Now you're saying in real time right there, the cop should have to tell you, or whoever, a cop should have to say to you, "I'm asking you for ID, but just so you're informed right here on the spot, you don't have to give it to me per your constitutional rights under the Fourth," correct?
Under the Fifth.
Under the Fifth, excuse me. We'll right to privacy and then right to not incriminate yourself. So wouldn't it be the Fourth and the Fifth?
No, because in Mimms, Hiibel, they justified that it's not a Fourth violation.
Okay, go on.
So, but they did say that it is a Fifth self-incrimination clause violation. And so, yes, and it sounds crazy, but think of how crazy that sounded to Miranda before Miranda rights were read, and people were getting questioned all the time and all these weird. I mean, that's the thing is they were getting interrogated.
It was used against them, and they didn't know that they could just shut the hell up, and you wouldn't be feeding them the information they need to lock you up in a cage, right?
Well, the thing is that under those interrogations, people will admit to things they didn't do. That's the thing. People will be pressured, or the cops will use tricks in order to getting people to think or admit to things that they didn't actually do. And so that's one of the reasons why Miranda is so important. But Miranda discovered that was there, and now it had to be implemented. And now, they have to read those during any interrogation and questioning for the answers to be admissible.
Now, is that every situation that you should have, like, for instance, what is your name? Do they have to say there to you, you have the right to remain silent, you don't have to give us your name, in other words? Or is it just when they ask you incriminating questions? What is the nuance there?
Well, for Miranda specifically, to read the actual Miranda rights would be when you're in custody and being questioned in a custodial setting.
So are you in custody when you get pulled over for speeding or a tag
light?
Right.
So they treat and everything I say mostly is often not related to traffic, even though I'm talking about Mimms. But the traffic law, it is kind of a weird situation. Like, for example, we can get in. So, for example, we'll get into the so the police don't actually have a seizure of somebody until they touch them or the person submits. Yeah, this is called the Hodari D case.
Are you submitting when you stop your car and let them seize you?
So all of that changes at the traffic on the highway though. So the cop doesn't have. So that's why I say if you're not on the highway, you're not seized until you're touched or you submit. But if you're on the highway, then you're seized as soon as like a marked vehicle or whatever.
Okay, so you're seized as soon as those lights come on, they're behind you. You might as well be seized. You have to stop, let them seize you, which means seize, aka stop. You are stopped. You are seized. You are now in their custody, so to speak. While they haven't physically touched you or handcuffed you, everyone knows damn well those lights come on behind you. You have to stop and be seized by the guy with the gun behind you with the flashy lights, right?
That's right.
So you are seized. Now, do your Miranda rights kick in then? Yes, no? Is there gray area? Tell me.
Okay, I'm gonna tell you honestly, when it comes to traffic, it's kind
like
of a whole new ball game.
Yeah.
I've studied traffic a lot,
Okay.
but I don't want to give any bad advice when it comes to traffic. I know when you're on the
Forget
street.
traffic. Sorry, I don't want to throw you off. Forget traffic. Let's for everything but traffic. All right, go ahead.
Okay. So, but if you're on the street like I was, or if you're sitting on your vehicle and not driving it like I was, say, and the cop comes up to you and says, "Let me see your ID," the Hiibel judges, yeah, you say, "Well, I invoke my Fifth Amendment right against self-incrimination. Therefore, I'm not obligated to provide my ID under Hiibel versus
Okay.
Nevada."
Okay.
Boom. That's really all you'd have to say. I mean, you know, these cops, you saw what happened to me. She'll still arrest you, but yeah, at least you got your 1983, you know? Yeah.
Okay.
And you can defend it that way in court. You can just pull it. So this is what Apex does. It pulls out all the quotes where all these cases were misinterpreted by, you know, the mainstream.
Hold on. You just said something there that people don't know about yet. Apex, when you're saying Apex, you're talking about this AI program that takes all these cases you're talking about, right? Explain that. Apex is an AI program that takes the cases we're talking about plus some other cases and does what?
Yeah, so it does what I call judicial jujitsu, you know, and it
Easy for you to say. Go on.
say it 10 times fast, right? So yeah, it takes all those cases and weaponizes them back against them instead of us.
Right.
Yeah, so not only is it designed to beat these criminal charges, but then to countersue, which is, see, that's what I learned from my mistake. If you don't countersue, and that's why, you know, I was asking about fishermen and all that stuff. Because you got to sue and hold them accountable, otherwise it just feeds the system. Every time we fail to countersue, they win. And the man gets stronger, you know. So if anyone, you know, it goes with ChatGPT, and then with, you know, you attach it like a document. It's because it's written in, it's like written in JSON file, which is like how like Python or like computer programs read, you know, read information. So,
All right, has he been Mirandized yet or
I
anything?
Mirandized him.
Oh, did he invoke?
He said he wanted a lawyer and then he kept talking. So this right here